Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. I've received a few communications from some listeners and followers that are interested in a notation that appeared on the case summary page, a PDF document telling us that this is a public record that the clerk of court has noted occurred in this case, but has not yet hit the docket itself, allowing the public at large to see this recent filing. I'm speaking of Judge Steven J. Hippler's order unsealing a stipulated motion for a sealed protective order and the sealed protective order itself, as the court did last week. And we know that that order has not yet hit the docket, but it has been rendered because it does appear on the very lengthy case summary page maintained by the clerk of court to note chronologically key events in the case that include notices of hearings, pleadings, the motions, responses, replies, court orders being another. And if you look at the docket, you'll see that as of today, and today is Sunday, it's the 2nd of February, we have not yet seen the order that Judge Steven Hippler rendered unsealing this previously sealed document. And I looked at the motion that asked the court to enter the prior order sealing this information from the public. And I think we can get some clues and rule out some possibilities simply by looking at the party that filed this motion seeking to have both the stipulation, that's the agreement that this document should be sealed, and the protective order itself should be sealed. In order to learn who filed this and what it states, we have to go back to January 10th, 2025. And at that time, the parties were very diligently, very busy preparing for the 2-day hearings in front of Judge Steven Hippler on the 13 motions to suppress evidence, the motion for a Franks hearing, and also a motion to compel discovery, all of which were defense motions application for a court order. So when you see a motion to suppress evidence, such as the motion to suppress the IGG evidence, that is the defense coming forward and saying, there's been a Fourth Amendment violation, Judge. This evidence needs to be thrown out of the case. That's a motion to suppress, seeking to have evidence that was obtained on a theory that it violated the Fourth Amendment suppressed, thrown out of the case. Therefore, the jury would not have an opportunity to see or hear or know about this evidence that, if it's granted, the suppression motion then orders this information to be thrown out. In looking at the filing of January 10th, 2025 motion application for a court order that came thereafter sealing what was requested here, we see that this is a stipulated. That means an agreement. Whenever you see the word stipulation or stipulated, this tells you that this is coming from the parties. Now, one of the parties has to file it, and usually it's the originating filer. In other words, if the defense wants to have responses to discovery sealed, what they have done on occasion is they have gone to the other side, to the defense, and asked if there's any opposition or if an agreement could be reached. And then it's the person who's wanting the information sealed will go ahead and file that document typically. So stipulated motion, that means this is an agreement between the parties, motion application for a court order, that a court order should be entered to seal the stipulated motion. So there's another document here. It's a motion upon a motion. It's the stipulated motion to seal, the stipulated motion for a sealed protective order. So the first part of this, it's complicated. You got to look at this a few times as I had to try to figure out what they're doing here. But it appears that what they're doing is the parties stipulated to ask the court to seal the stipulated motion to seal a protective order and the protective order in question. Stipulated motion for another stipulated motion. We get that from the title. Now, let's look at what this filing stated. Comes now Brian C. Kohberger. So right away we see that this is coming from the defense. The defense is actually filing this, and they are the originating party. They would typically then have it incumbent upon them to go to the other side and see if there's an agreement here. But let's read what this says. Comes now Brian C. Kohberger by and through his attorneys of record, and with a no objection from the Latah County Prosecuting Attorney's Office, hereby moves the court for an order to seal the stipulated motion for sealed protective order and the sealed protective order. So you can see here they've done exactly as we thought. The defense contacted the Latah County Prosecuting Attorney's Office and said something to the effect of, just speculating here, hey, I want to file this document under seal with this proposed order. Do you agree? Do you have any disagreements? Do you object to this? Nope. No objection. So then, part 2, hereby moves the court for, it's really the entry of an order to seal the stipulated motion for sealed protective order and the sealed protective order itself. There's a couple of documents here behind the scenes. The stipulated motion is made pursuant to ICAR 32. That's the rule of court that allows certain documents, if they meet a criteria, to be sealed from the public, because the public really should be able to, in our system of government, walk into any courtroom at any time in any state in the United States and watch pre-trial or trial matters. This has been all but impossible here because of the vast number of things that have been sealed from the public and the large number of hearings that have been sealed to the public. Most recently been 9:00 a.m. on the 23rd of January, when testimony relative to the pending, not yet ruled upon motion for a Franks hearing and testimony for the IGG DNA suppression motion was held behind closed doors, sealed to the public. So, what can we try to make educated guesses about? And this is pure speculation based on the filings. Well, it's probably not anything like a no contact order or any of the matters that the state initiated to protect surviving roommates, to protect family members of the 4 young people who were unalived. That all came from the state. So it doesn't sound like it's that, nor does it sound like it could be relative to the family tree members or the organizations that provided that type of service that were deemed to be informants by virtue of the 2023 order rendered by Judge, who was then the presiding jurist over the case. If you haven't read that order, I recommend you do. It is very long, but it goes into what's happened here regarding IGG DNA and why it is this is a case of first impression, meaning that not a lot of courts out there have dealt with this type of an issue. So also, we had the defense who recently tried to get the IGG records unsealed, and they were unsuccessful in doing that. So it doesn't sound like it's anything having to do with the family tree or the organizations who provided those type of genealogical services who have been deemed as informants in this case, because that just seems to be in conflict with what the defense tried to do here recently in getting these matters unsealed. A possible situation might be a witness that testified at the hearings, because this is everything that was going on at that time. Just take a look at the docket and see how many things the court rendered in order, telling the parties that they needed to provide information by a date certain regarding who they would be calling on the stand and evidence that they would be marking into evidence in the case. We saw requests to have out-of-state witnesses be able to testify via Zoom and not in person. We saw a lot of things happening at around that time that makes it unlikely that this was having to do with anything but the hearings. Now, again, that is pure speculation. It could be something else entirely, but it does seem as though this is for a person of some kind. Protective order. That just seems like it could possibly be for documents. It just seems like it's for a person. We're going to find out very soon. We should be having this order hit the docket because other things that have been filed around that time have already been docketed. So hopefully it'll be Monday or Tuesday of this coming week where we're going to have an opportunity to read what Judge Hippler unsealed. And of course, I'll report back to you with my findings and my thoughts. Until then, this is Kathy. Thanks for joining us here today.